the Supreme Court has made a huge and unexpected decision which is uprooting gun laws all across the U.S. Let's dive in and find out what has happened. Landmark Supreme Court decisions. A landmark U.S. Supreme Court decision on the Second Amendment is upending gun laws across the country, dividing judges and sowing confusion over what firearm restrictions can remain on the books. The High Court's ruling that set new standards for evaluating gun laws left open many questions, experts say, resulting in an increasing number of conflicting decisions as lower court judges struggled to figure out how to apply it. The Supreme Court's so-called Bruin decision changed the test that lower courts had long used for evaluating challenges to firearm restrictions. Judges should no longer consider whether the law serves public interests, like enhancing public safety, the justices said. Under the Supreme Court's new test, the government that wants to uphold a gun restriction must look back into history to show it is consistent with the country's historical tradition of firearm regulation. Courts in recent months have declared unconstitutional federal laws designed to keep guns out of the hands of domestic attackers, felony defendants, and people who use marijuana. Judges have shot down a federal ban on processing guns with serial numbers removed and gun restrictions for young adults in Texas, and have blocked the enforcement of Delaware's ban on the possession of homemade ghost guns. In several instances, judges looking at the same laws have come down on opposite sides on whether they are constitutional in the wake of the conservative Supreme Court majority's ruling. The legal turmoil caused by the first major gun ruling in a decade will likely force the Supreme Court to step in again soon to provide more guidance for judges. Jacob Charles, a professor at Pepperdine University's law school who focuses on firearms law, said, "There's confusion and disarray in the lower courts because not only are they not reaching the same conclusions, they're just applying different methods or applying Bruin's method differently. What it means is that not only are new laws being struck down, but also laws that have been on the books for over 60 years, 40 years in some cases, those are being struck down, where prior to Bruin, courts were unanimous that those were constitutional." The legal wrangling is playing out as mass shootings continue to plague the country awash in guns, and as law enforcement officials across the U.S. work to combat an uptick in violent crime. In recent months of 2023, multiple people were fatally shot at multiple locations in a small town in rural Mississippi, and a gunman slayed 3 students and critically wounded 5 others at Michigan State University before slaying himself. Dozens of people have perished in mass shootings so far in 2023, including in California, where 11 people were slain as they welcomed the Lunar New Year at a dance hall popular with older Asian Americans. Last year, more than 600 mass shootings occurred in the U.S., in which at least 4 people were slain or wounded, according to the Gun Violence Archive. The decision opened the door to a wave of legal challenges from gun rights activists who saw an opportunity to undo laws on everything from age limits to AR-15-style semi-auto weapons. For gun rights supporters, the Bruin decision was a welcome development that removed what they see as unconstitutional restraints on Second Amendment rights. As this recent decision struck down the New York law that restricted the concealed carry of handguns, it has opened the door to challenges to other gun control laws. If the Supreme Court were to rule that the Second Amendment protects the right to own suppressors, it would be a major victory for gun rights advocates. The Bruin case verdict. The issue around the right to carry guns in public in the United States has been a contested area in politics and constitutional law for most of the 21st century. Prior to the case, the Supreme Court established 2 major decisions toward gun possession in one's home. District of Columbia versus Heller affirmed that U.S. citizens did have an individual right, unconnected to a well-regulated militia, to possess guns within their own homes under the Second Amendment, and McDonald versus City of Chicago affirmed this was a right that was incorporated against the states. However, the question of ownership outside of one's home had not yet reached the Supreme Court, and instead was based on an inconsistent framework of state laws and federal court decisions.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
These decisions were generally based on long-standing common law that the government does have the ability to regulate firearms in public spaces to uphold state regulations on public gun possession. Across over 1,000 cases since Heller, most federal appeals courts have used intermediate rather than strict scrutiny to judge the validity of public carry gun control laws, which defer to the state's compelling interest to protect the public by restricting possession of guns in public spaces. To combat growing criminal violence in certain neighborhoods of New York City, including the assassination attempt on New York City Mayor William J. Gaynor and the slaying of author David Graham Phillips, Timothy Sullivan led the state legislature to enact the Sullivan Act in 1911. It made the possession of a handgun without a permit a crime and instituted issuance of concealed carry permits at the discretion of local law enforcement. The law states that to obtain a permit, the applicant must demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. The state had clarified that this must be a non-speculative need for self-defense, as to establish a proper cause to grant a permit. The New York State Rifle and Pistol Association, along with Robert Nash and Brandon Koch, who failed to obtain a permit in New York State, challenged that law, seeking to make the issue of permits no longer discretionary. Nash, for example, sought a permit for a handgun after a string of robberies in his neighborhood, but was denied as he could not prove a need for self-defense. The plaintiffs argued that the law and judgments against their permits were flawed. Good, even impeccable moral character, plus a simple desire to exercise a fundamental right, is, according to these courts, not sufficient, nor is living or being employed in a high-crime area. The Sullivan Act is considered the first May-issue public carry law in the U.S., since the discretion on allowing a person to carry a gun in public is based on the evaluation of need, which 7 other states adopted from New York. This is in contrast to more recent shall-issue licensing requirements based on determinant methods such as using background checks and aptitude checks to determine eligibility. The petitioners had asked the Supreme Court to review their case, specifically pressing the question of whether the Second Amendment allows the government to prohibit ordinary law-abiding citizens from carrying handguns outside the home for self-defense. The Supreme Court granted certiorari on April 26, 2021, although it limited the case to the question of whether the state's denial of petitioners' applications for concealed carry licenses for self-defense violated the Second Amendment. The case was heard on November 3, 2021, and was the first major gun rights case that the Supreme Court had heard in more than a decade.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
It was also the first gun rights case to be heard by the 6-member conservative majority, which included Justices Clarence Thomas, Neil Gorsuch, and Brett Kavanaugh, who in prior opinions had emphasized the need for the Supreme Court to review the current stance on Second Amendment cases. The case's decision was released on June 23, 2022. In a 6-3 opinion authored by Justice Clarence Thomas, the court held that the state law was unconstitutional, as it infringed on the right to keep and bear arms, reversing the Second Circuit's decision and remanding the case for further review. Thomas's majority opinion, joined by Chief Justice John Roberts and Justices Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, effectively rendered public carry a constitutional right under the Second Amendment. Thomas wrote, "The constitutional right to bear arms in public for self-defense is not a second-class right, subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need." The court's decision in Bruin was a major victory for gun rights advocates. The court's ruling overturned a long-standing precedent that had allowed states to impose strict restrictions on the concealed carry of firearms. The decision also opened the doors to challenges to other gun control laws, such as bans on other weapons and high-capacity mags. The Bruin decision has been met with mixed reactions. Gun rights advocates have praised the decision, arguing that it will help to protect their Second Amendment rights. Gun control advocates have criticized the decision, arguing that it will make it easier for people to carry guns in public, which could lead to an increase in gun violence. Reactions across the nation. Gun control groups are raising alarm after a federal appeals court in 2023 said that under the Supreme Court's new standards, the government can't stop people who have domestic violence restraining orders against them from owning guns. The New Orleans-based 5th U.S. Circuit Court of Appeals acknowledged that the law embodies salutary policy goals meant to protect vulnerable people in our society. But the judges concluded that the government failed to point to a precursor from an early American history that is comparable enough to the modern law. Attorney General Merrick Garland has said that the government will seek further review of that decision. Gun control activists have decried the Supreme Court's historical test, but say they remain confident that many gun restrictions will survive challenges. Since the decision, for example, judges have consistently upheld the federal ban on convicted felons from possessing guns. The Supreme Court noted that cases dealing with unprecedented societal concerns or dramatic technological changes may require a more nuanced approach, and the justices clearly emphasized that the right to bear arms is limited to law-abiding citizens, said Shira Feldman, litigation counsel for Brady, the gun control group. The Supreme Court's test has raised questions about whether judges are suited to be poring over history and whether it makes sense to judge modern laws based on regulations, or lack thereof, from the past. We are not experts in that white, wealthy, and male property owners thought about firearms regulation in 1791, yet we are now expected to play historian in the name of constitutional adjudication, wrote Mississippi U.S. District Judge Carlton Reeves, who was appointed by President Barack Obama. Firearm rights and gun control groups are closely watching many pending cases, including several challenging state laws banning certain semi-auto weapons and high-capacity magazines. A federal judge in Chicago recently denied a bid to block an Illinois law that bans the sale of so-called attack weapons and high-capacity mags, finding the law to be constitutional under the Supreme Court's new test. A state court, however, already has partially blocked the law, allowing some gun dealers to continue selling the weapons amid a separate legal challenge. Already, some gun laws passed in the wake of the Supreme Court decision have been shot down. A judge declared multiple portions of New York's new gun law unconstitutional, including rules that restrict carrying firearms in public parks and places of worship. An appeals court later put that ruling on hold while it considers the case, and the Supreme Court has allowed New York to enforce the law for now. Some judges have upheld a law banning people under indictment for felonies from buying guns, while others have declared it unconstitutional. In the California case, U.S. District Judge George Wu, who was nominated by President George W. Bush, appeared to take a dig at how other judges are interpreting the Supreme Court's guidance. The company that brought the challenge, and apparently certain other courts, would like to treat the Supreme Court's decision as a word salad, choosing an ingredient from one side of the plate, an entirely separate ingredient from the other, until there is nothing left whatsoever other than an entirely bulletproof and unrestrained Second Amendment, Wu wrote in his ruling. Modern Arms Second Amendment. Modern arms, despite the claims of anti-gun activists, are indeed protected by the Second Amendment of the U.S. Constitution. While anti-gun activists argue that the right to bear arms should not extend to contemporary firearms, a thorough examination of the Second Amendment's principles and the evolving nature of self-defense always reveals the continued relevance of modern arms within its protections. To understand the Second Amendment's applicability to modern arms, it is essential to consider the historical context in which it was written. When the amendment was ratified in 1791, muskets and rifles were the predominant firearms of the time. Critics contend that the framers could not have anticipated the technological advancements that have since occurred in the field of weaponry. While this is undoubtedly true, it is important to remember that the underlying principles of self-defense and individual liberty that the Second Amendment upholds remain unchanged. The interpretation of the Second Amendment has been a subject of intense debate. However, the Supreme Court has consistently affirmed that the right to bear arms is an individual right, distinct from militia service. Like we have seen in key cases such as District of Columbia v. Heller and McDonald v. City of Chicago, the court clarified that the Second Amendment protects the right to self-defense within the home and encompasses firearms in common use for lawful purposes. Consequently, modern firearms, which are widely owned and commonly used for self-defense, fall within the ambit of constitutional protection. Self-defense is a fundamental aspect of the Second Amendment's purpose. Modern firearms provide individuals with the means to protect themselves and their loved ones from immediate threats. The possession of firearms with features like semi-auto capabilities and higher capacity mags offers a significant advantage in emergency situations. These modern arms enable law-abiding citizens to respond effectively to potential harm, thereby enhancing their personal safety. By deterring criminals and providing a means of self-defense, modern firearms contribute to the overall security of individuals and communities. In addition to self-defense, the protection of modern arms under the Second Amendment acknowledges the evolving nature of the threats faced by citizens. Technological advancements have empowered criminals, but they have also empowered law-abiding individuals to confront and mitigate those threats effectively. From home invasions to mass shootings, the right to possess modern firearms ensures that citizens have access to tools that match the capabilities of those who seek to do harm. Stripping individuals of the ability to defend themselves with modern arms would create an imbalance, leaving law-abiding citizens vulnerable to those who are willing to break the law. The argument against modern arms often revolves around the notion that they are unnecessary or excessive for self-defense purposes. However, the Second Amendment does not dictate the specific types of firearms protected. Instead, it upholds the principle that individuals have the right to possess arms that are in common use and suitable for lawful purposes. Modern firearms clearly fall within this definition, as they are widely owned and used by law-abiding citizens for self-defense, sport shooting, and other lawful activities. So attempts to restrict or ban modern arms based on their aesthetic features or capabilities undermine the core principles of the Second Amendment. The focus should be on addressing the underlying causes of violence and crime, rather than targeting the tools used by criminals. Responsible firearm ownership, education, and comprehensive background checks are effective means of addressing concerns related to public safety without infringing on the rights protected by the Second Amendment.
Selling more guns in the last 3 weeks than we did in the last 8 months.
Furthermore, firearm technology has evolved significantly since the framing of the Second Amendment. Alongside advancements in firearms themselves, various accessories have emerged to enhance their functionality and safety. Suppressors, developed to reduce the noise and muzzle flash of firearms, have become increasingly prevalent in contemporary firearm use. Though originally invented in the early 20th century, modern suppressors now incorporate advanced materials, designs, and manufacturing techniques, solidifying their status as modern arms. The Second Amendment guarantees the right to bear arms, encompassing firearms in common use for lawful purposes. While some argue that suppressors are not intended for self-defense and thus should not be protected, this overlooks their significant practical applications. Suppressors play a crucial role in hearing protection, reducing noise pollution, and minimizing recoil, contributing to safer shooting experiences. Their use in hunting can help mitigate noise disturbances and improve accuracy. As such, suppressors fall within the purview of the Second Amendment's protections for modern arms. Suppressors have often been subject to misconceptions perpetuated by media portrayals and popular culture. Contrary to their depiction as tools exclusively utilized by criminals or assassins, suppressors primarily serve lawful purposes such as recreational shooting, hunting, and home defense. Acknowledging their lawful applications and demystifying their capabilities are crucial steps towards understanding why suppressors should be protected under the Second Amendment. The inclusion of suppressors in the category of modern arms aligns with the objective of promoting firearm safety and accessibility. By mitigating the loud noise associated with firearm discharge, suppressors help reduce hearing damage risks, making shooting ranges and hunting environments safer for both firearm users and bystanders. Their use can make shooting activities more accessible to individuals who may be sensitive to loud noises or have heightened auditory concerns. While acknowledging suppressors as modern arms, it is important to emphasize the need for responsible ownership and regulation. Striking a balance between individual rights and public safety, the implementation of thorough background checks, training requirements, and registration processes can ensure responsible usage and deter misuse. Such measures can address concerns regarding the potential misuse of suppressors while upholding the rights protected by the Second Amendment. Despite the claims of anti-gun activists, modern arms and suppressors are pretty much protected by the Second Amendment. The right to bear arms extends to firearms that are in common use for lawful purposes, including those that have seen technological advancements. The Second Amendment acknowledges the changing dynamics of self-defense and the need for individuals to adapt to evolving threats, and so suppressors, as modern arms, deserve protection under the Second Amendment. Their evolution in design and functionality aligns with the broader advancements in firearm technology. Texas AG sues ATF. In another interesting bit in this situation, it's a long shot, but Texans may soon be able to make firearm suppressors without going through the federal process. In accordance with a new state law, Texas Attorney General Ken Paxton sued the ATF in an effort to stop the federal government from regulating silencers that are made in Texas. Federal laws and regulations which tax and regulate the making of firearm suppressors in Texas for personal use in Texas impinge upon a right protected by the Second Amendment, the lawsuit reads. The state law, House Bill 957 by Rep. Tom Oliverson, attempts to exempt Texas-made suppressors from federal regulation.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal. The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton." He went on to say he looks forward to a quick resolution in the Texas Senate.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Ever since gangland crimes like the St. Valentine's Day slaying spurred Congress to pass the National Firearms Act in 1934, citizens have had to pay the ATF $200 for a tax stamp to purchase suppressors. Federal regulations also require suppressors to be registered in a national registry. Manufacturers must have a license with the ATF to make suppressors, and even individuals that want to make suppressors for personal use must pay the tax stamp and get advance approval from the ATF. HB 957 says these regulations do not apply to suppressors made in Texas, and also forbids state and local police from enforcing federal suppressor regulations. However, to keep regular citizens out of trouble with the ATF, it first directs the Texas Attorney General to seek a declaration from a federal court that HB 957 is constitutional on behalf of a Texan looking to manufacture a Texas-made suppressor. The ATF warned licensees in Texas that it would still enforce federal law even after the passage of HB 957. After months passed with no action from Paxton, most suppressor companies in Texas remained dubious that HB 957 would actually work. Because the companies risk losing their licenses for violating the NFA, one owner suggested that an individual might be better suited to contact Paxton and challenge the law. Paxton filed his lawsuit on behalf of 3 Texans who told him they intend to make suppressors for personal use that will remain in Texas. The citizens say suppressors would enable them to defend their homes without earplugs, allowing greater alertness without the risk of hearing damage. Oliverson, a medical doctor, presented similar arguments when laying out the bill on the floor of the Texas House. In the brief, Paxton argues that the federal government has no compelling interest in suppressor regulation that could outweigh the Second Amendment and supporting precedent like D.C. versus Heller. Specifically, Paxton claims the $200 tax stamp does not generate revenue, failing even to pay the cost of collecting the tax itself, and that suppressors pose no obvious criminal danger as opposed to items like grenades. The government cannot demonstrate that taxation and regulation of firearm suppressors, unlike dangerous items like hand grenades, is necessary for public health and safety. The government cannot point to any harm that taxing and regulating firearm suppressors alleviates, the lawsuit reads. Calling the inclusion of suppressors in the NFA merely a historical accident, Paxton notes that Congress landed on the $200 price tag since that was the average cost of a MAC gun at the time. Additionally, the NFA definition of firearm excludes most guns, such as common long shotguns or rifles, but includes suppressors and their component parts if their owners intend to use them to build suppressors. Thus, a metal pipe is a firearm subject to taxation and regulation under the National Firearms Act of 1934, if the owner of the metal pipe intends to incorporate it into a firearm suppressor. Other metal pipes are not defined as firearms in the statute according to Paxton. Other NFA firearms include short shotguns and rifles, mash guns, and grenades, making suppressors the only gun accessory in the law. Paxton is seeking 2 permanent injunctions. One would stop the ATF from assessing the tax stamp. The other would stop the ATF from enforcing federal gun regulations that impose duties besides taxes on the making of suppressors in Texas for personal use in Texas. More broadly, he also seeks the declaration that federal regulation on suppressors is not a valid exercise of power. Gun control advocates support government regulation of silencers to keep them out of the hands of criminals. They argue silencers make it harder to locate a shooter's location, hampering police response to shootings. Muffled gunshots also reduce the chance of bystanders reporting gunfire to police, the group say. But most Texans don't seem to agree. After all, Texas, the second most populous state, led the U.S. in 2020 for the number of manufacturers and dealers of silencers, as well as other specialized weapons, such as short-barreled rifles, short-barreled shotguns, and mash guns, according to ATF. Texas, as of May 2021, had more registered silencers than any other state, with more than 520,000. Florida was second, with more than 175,000 registered silencers. California, the most populous state in the U.S., had little more than 17,000 registered silencers. Challenges to gun law. The Supreme Court left intact a federal law that requires the registration of some firearms, including silencers, and turned away a request to consider whether such firearm accessories are protected by the Second Amendment. An appeals court had held that a silencer is not a bearable arm protected by the Constitution. The case comes as a silencer was used during the recent Virginia Beach massacre, and President Donald Trump
blatantly denying the power grab being carried out by the executive branch yet again.
The uptick in violence has just been astronomical. The gun violence.
As a kid, I came out of a different movement, the civil rights movement.
Who showed up here said one thing that felt good about doing this kind of event was that they felt empowered.
Pretty clear about the extent to which this is an abuse of the Administrative Procedures Act.
Is it a difficult question to understand?
I'm sure it's enormously high.
It's 36 per 100,000 people.
With it off safe, just that little bit of motion, you can hear the click.
Suggested he'd look into restrictions on gun silencers. The Trump administration had also urged the court not to take up the issue. The order was issued without comment or recorded dissent. Shane Cox owned an Armory surplus store in Kansas where he sold unregistered homemade silencers, and Jeremy Kettler bought one of them. They were convicted under the National Firearms Act, passed in 1934, which requires individuals to register silencers and to pay a federal tax of about $200. The law has the effect of limiting the number of silencers, but not banning them.
Because he doesn't care about separation of powers either.
The Texas House of Representatives just voted to impeach Texas Attorney General Ken Paxton.
How many guns has the ATF lost? I'm not sure I understand the question.
It will shoot, then it comes back forward. The rifle will then cycle and cock again.
The extent to which this is an unconstitutional violation of our Second Amendment rights. But what is also true is that it is incumbent upon the United States Congress, the House of Representatives in particular.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
It also makes it harder to transfer them. 8 states and Washington, D.C. go further and ban silencers altogether. Others ban them unless registered with the Bureau of Alcohol, Tobacco, and Firearms. Court experts did not expect the court to take up this issue, but believe justices are more likely to look at other issues concerning public carry and assault weapons. Some believe the lower courts are thumbing their nose at the landmark Heller v. U.S. decision in 2008, holding that the Second Amendment protects an individual's right to keep and bear arms. Earlier in this term, the justices did agree, however, to take up a Second Amendment case for next term about a New York City gun law.
And having to tell her that other 9-year-olds were just killed in a shooting is horrific.
Field background checks could stop a lot of illegal guns going in different places in the country.
This shall not be infringed, and the word infringe means by banning parts on firearms actually is against the Constitution.
It takes extraordinary courage for them to stand up here and retell the story.
Anti-gunners put in there to keep the guns out of the hands of lawful citizens in New York State.
Affect us here, and it was such a breath of fresh air for the Second Amendment people.
Concerning the transport of guns outside the home. Expanding gun rights. In a major expansion of gun rights after a series of mass shootings, the Supreme Court said that Americans have a right to carry firearms in public for self-defense, a ruling likely to lead to more people legally armed. The decision came out as Congress and states debate gun control legislation. About 1/4 of the U.S. population lives in states expected to be affected by the ruling, which struck down a New York gun law.
June of 2021, you changed the department's asylum rules so that it could apply to individuals with significant gang violence.
Most apparent here a defense of the Second Amendment, which this most certainly is.
Wyme says the Missouri law exposes people to greater harm by interfering with the federal government's ability to enforce firearms regulations.
We can expect in the future that more people will be carrying handguns on the streets in places like Los Angeles, Boston, and New York City.
As many of you out there, either parents, relatives, and/or victims yourself,
to do anything about what the president is doing to exercise that authority unconstitutionally, as was the case with student loans.
Because people buy hundreds of guns legally and then they sell them illegally.
The High Court's first major gun decision in more than a decade split the court 6-3, with the court's conservatives in the majority and liberals in dissent. Across the street from the court, lawmakers at the Capitol sped toward passage of gun legislation prompted by recent massacres in Texas, New York, and California. Senators cleared the way for the measure, modest in scope, but still the most far-reaching in decades.
Inventing the pistol stabilizing brace to help his friend, a disabled combat veteran, at the shooting range.
You gave testimony that the brave ATF agents are the ones showing up at 2 in the morning after a burglary.
Do any of my colleagues on the other side of the aisle give a whit about separation of powers?
Connecticut delegation, which is incredible. I think on this issue and many others, you're the best delegation in the United States.
No guns were lost. They were stolen by an individual who's now in prison.
And of course, we've got a lot of criticism over this. So why is it not a machine gun?
In areas that are poor, mostly minority, there's a mass shooting.
Congress wants to change the law and come up with a new interpretation, then ATF will follow that new interpretation.
She proves you can run for office ending gun violence in the South and you can win.
AK-47 is an automatic Kalashnikov model of 1947.
You can prevent the next tragedy. You can save life. You can save families in the process.
Thought it just like, wow, it doesn't fit the definition. It doesn't fit the rulings, but we better run this up the chain.
Some months later, during an ATF audit, I was told the background check was now a non-approval.
Because they like the outcome of the policy, the banning of a piece of plastic.
Highlighting the nation's profound divisions on the matter, the sister of a 9-year-old girl who was killed in the Uvalde, Texas school shooting pleaded with state lawmakers to pass gun legislation. The Republican-controlled legislature, which has steadily removed gun restrictions over the past decade, remains at the center of the debate. President Joe Biden expressed his deep disappointment with the Supreme Court ruling in a statement. He stated that the ruling contradicts both common sense and the Constitution and should be a cause for concern for all citizens. The president called upon states to enact new laws, urging Americans across the country to raise their voices on the issue of gun safety, emphasizing that lives are at stake.
That requirement for showing a heightened need for self-defense, that was the teeth of these permitting laws.
And within less than 15 minutes, you can walk out the front door here with a rifle or a shotgun.
American citizens in places like New Orleans and Baltimore and St. Louis begin to seek asylum in countries like Honduras and Guatemala.
I don't know if you're referring to any particular incident or
to run enhanced background checks on young people under 21 trying to buy a firearm.
This government can protect its own people, except for 36 out of every 100,000 for murders.
Types of disputes that would be settled by people yelling at each other, maybe engaging in a fist fight, are being settled with guns.
The Supreme Court's decision invalidated a New York law that required individuals to demonstrate a specific need for carrying a concealed firearm in public in order to obtain a license. The justices concluded that this requirement violates the Second Amendment right to keep and bear arms. Justice Clarence Thomas wrote for the majority that the Constitution protects an individual's right to carry a handgun for self-defense outside the home. That right is not a second-class right, Thomas wrote. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. California, Hawaii, Maryland, Massachusetts, New Jersey, and Rhode Island all have laws similar to New York's. Those laws are expected to be quickly challenged. Governor Kathy Hochul, Democrat New York, said the ruling came at a particularly painful time, with New York mourning the deaths of 10 people in a shooting at a supermarket in Buffalo. This decision isn't just reckless, it's reprehensible. It's not what New Yorkers want, she said.
I'm just inspired by the next generation. I think it's a time for a big change.
Since you rewrote the rules of asylum based on the perceived degree of violence in these countries.
Selling more guns in the last 3 weeks than we did in the last 8 months.
But for me, and for most of you, here's what it really is. It's an important first step.
When somebody bump fires, think of this as a bump fire stock and able to move.
To be clear, this wasn't based on violence. This is based on threats specifically to individuals, on gangs.
I don't really see the purpose of letting other people that don't really know what harm they can do.
You specifically said that.
But I said...
What does mandatory mean?
I'm trying to say that...
Does it mean that prosecutors get a choice?
I would expect to see in the coming months and years is a lot of focus on whether or not enough places are deemed sensitive right now.
The Attorney General himself, Ken Paxton, tweeted saying, quote, "What we just witnessed is illegal."
Gun control groups called the decision a significant setback. Michael Waldman, president of the Brennan Center for Justice and an expert on the Second Amendment, wrote on Twitter that the decision could be the biggest expansion of gun rights by the Supreme Court in U.S. history. Republican lawmakers were among those cheering the decision. Tom King, president of the plaintiff New York State Rifle and Pistol Association, said he was relieved.
We are not finished. We are not finished. We are not finished.
Not one more! Not one more! Not one more!
The most serious readily provable offenses in cases where mandatory minimums are present because it's not warranted.
The sensitive places doctrine was not at issue in this case and still exists.
He went on to say he looks forward to a quick resolution in the Texas Senate.
So what happens is I pull the gun into my trigger finger.
Who are prepared and carry a gun oftentimes have to make split-second decisions.
The lawful and legal gun owner of New York State is no longer going to be persecuted by laws that have nothing to do with the safety of the people and will do nothing to make the people safer, he said. And maybe now we'll start going after criminals and perpetrators of these heinous acts. The court's decision is somewhat out of step with public opinion. About half of the voters in the 2020 presidential election said gun laws in the U.S. should be made stricter, according to AP Votecast, an expansive survey of the electorate. An additional 1/3 said laws should be kept as they are, while only about 1 in 10 said gun laws should be less strict.
The conventional wisdom was we would never get any Republicans to support gun legislation, period.
Are ones where, in fact, it's most likely that they should be bringing the highest and mandatory minimum.
Details of the law, but folks, listen at home. Here's a quick summary of what this law is doing. It's already allowing.
Are demonstrating that blind loyalty to Speaker Dade Phelan is more important than upholding their oath of office.
Might end up being a message amendment because the President of the United States will almost assuredly veto it.
Justice Brett Kavanaugh and Chief Justice John Roberts criticized the Supreme Court's decision to strike down New York's law on concealed handguns in public. They noted that states can still require people to obtain a license to carry a gun and condition that license on fingerprinting, background checks, mental health records checks, and training in firearms handling and force laws. Gun violence has increased during the coronavirus pandemic, and gun purchases have also risen. New York's law, in place since 1913, requires a specific need to carry the weapon. The New York State Rifle and Pistol Association and 2 men sought an unrestricted ability to carry guns outside their homes.
What about Colombia?
I don't know.
23 per 100,000.
It's ludicrous. That doesn't happen. We are the lawful, legal citizens of the state.
Holding it a certain way, it'll continue to bump back and forth against my trigger finger.
Which many have described as the most significant gun safety law in 30 years, and it is.
The Supreme Court last issued a major gun decision in 2010, establishing a nationwide right to keep a gun at home for self-defense. Justice Stephen Breyer criticized the ruling, arguing that it would severely burden states' efforts to pass laws that limit who may purchase, carry, or use firearms of different kinds. Other conservative justices also contributed to the discussion. Justice Samuel Alito criticized Breyer's dissent, questioning the relevance of his discussion of mass shootings and other gun death statistics. That's all for today, folks. We'll see you next time.